The Gqeberha High Court in the Eastern Cape has dismissed the National Prosecuting Authority's application for leave to appeal the acquittal of televangelist Timothy Omotoso and his co-accused Lusanda, Sulani and Zukiswa Sitho were found not guilty in April on charges of rape and human trafficking. Judge Irma Schoeman cited the failure of the state to prove its case well beyond a reasonable doubt and slammed the conduct of the NPA in handling the matter. The state contends Judge Schoeman erred in law when she found Omotoso and his co-accused not guilty.
This is a judgment in the case of the state versus Omotoso and two others. I'm just going to read the order. The application to have the 6 questions of law is dismissed. I hand down the judgment.
All right, we have roped in legal analyst Mr. Elton Hart to help us unpack these latest developments in this matter. Mr. Hart, it's a pleasure, sir. Thank you so much for your time. So another blow for the NPA in its failed bid to appeal Omotoso's acquittal. But what does this then in essence mean for the state? Can they still further pursue the matter at the Supreme Court of Appeal? Good afternoon.
Afternoon and afternoon to the viewers. Indeed, the NPA can now petition the Supreme Court of Appeal to actually have a look at this appeal of this and decide whether they have a right to actually approach the Supreme Court of Appeal in Bloemfontein to come to them to say that we feel that the trial court misdirected itself in looking at the evidence, looking at the witness testimony, and also the prosecutorial misconduct that happened in the trial as alleged by or as stipulated by Judge Schoeman back then. So they can go there. So it's not the end of the road for them. So they can still go to the Supreme Court of Appeal, and they can also go to the Constitutional Court if the need arises.
But maybe, Elton, please explain the context of the judgment in this appeal application, right? Judge Schoeman, again, finding the state had failed to prove its case beyond reasonable doubt and deemed several witnesses unreliable, which was similar to a previous ruling, right? But the state is still arguing the opposite, questioning whether the court had properly applied the element of racketeering, as well as those allegations of prosecutorial misconduct, among a range of their objections. But are these valid arguments by the state, specifically at this time?
I think how the state is going about this thing, for me, is wrong. They just need to sort of do their appeal, petition to the necessary court, get the necessary permission to actually approach that court. Now they're seeking to get clarification on certain issues from the very same court where the judgment was granted. So it becomes a little bit difficult for a judge to now say, oh, I was wrong. You need to go to either the full bench or go to the Supreme Court of Appeal. And I think now they were in front of the full bench because Judge Irma was a one-man sitting on this matter. So for me, the way they're approaching it, I'm not saying that some of the things that they're saying is unfound, but if one balances what the state has brought to the table and what the defense has brought to the table, I think the pendulum swung in favor of the defense. Because obviously if the judge finds that certain witnesses is unreliable, and also what did not help the state's case, it was that a lot of these witnesses were in a WhatsApp group, so you can't really say that they actually corroborate each other to show that there was predatory conduct by Omotoso and his team, because it seems like this is a coached event. And also how the prosecutors in cross-examining the defense witnesses, so they never actually put the state's case to them and actually try and discredit the defense witnesses. So it seems like whatever the defense put on the table as a version, as a probable version, was accepted by the court. And remember, in criminal court, the defense does not need to prove that they are innocent. The state must prove beyond reasonable doubt. So the doubt must be very, very limited that this person has committed these offenses.
You know, when you look at that angle, then, Elton, let's say these were valid arguments, right? Can the NPA then specifically then deal with the judge for her conduct as a counter-argument, since she also tore into the prosecution team's conduct, citing all kinds of unpreparedness and unprofessionalism? How would that particular process then unfold?
Obviously, the NPA cannot address the judge now in this matter, in this trial, or the leave to appeal. When one needs to address a judge for their conduct, you need to approach the Judicial Services Commission to say that this judge was ill-treating us, and you report the judge or the magistrate to the Magistrates Commission. So that's a separate issue. But for me, the NPA, as I look at it, they've got an uphill battle because first and foremost, you need to look at the witnesses. And already if a judge says that I cannot rely on the evidence of a witness, it means that the witness is unreliable. And then it now means you are stuck with what's on the record. If that witness did not bring something more to the table to prove beyond reasonable doubt that that man and his co-accused committed these offenses, you are in a catch-22 situation. So I think for the NPA to say that factual findings is like the trial court is best suited because they can see a witness when they testify, look at their demeanor, look at how they're testifying to make that. And normally an appeal court would not necessarily interfere with that factual finding by the lower court. They will just look at the principles of law. And I think when she goes and says the witness is unreliable, and if a witness is not reliable, then you cannot rely on that evidence. And then you look at the legal principles that she applied. And I think Judge Irma Schoeman, she's a seasoned veteran. She would not make a rookie mistake like that. I think the NPA was sloppy in how they presented this case.
I would have loved to deliberate further into this, Elton. Unfortunately, we're out of time. We're going to leave it there. Thank you so much for your sound analysis. Mr. Elton Hart is a legal analyst there weighing in on the Omotoso appeal matter that was rejected by the court.